All right, everybody. Welcome into civil procedure. Today we are going to cover what's called the authority of the court, right? The threshold issues of personal jurisdiction, subject matter jurisdiction, and venue, right? These are the foundational issues that you've got to master before you can analyze anything else in a civil lawsuit, right? So they're among the most heavily tested subjects on the California bar, the most heavily tested subjects. Here's the most single important thing I want you to understand coming into today's lecture before a court can hear any case, it must have the legal authority to do so, right? So a court that does not have proper authority must dismiss the case. It doesn't matter how strong the plaintiff's matters and the merits are. It doesn't matter how clear the defendant's liability is. No authority means no case. It's that simple. So memorize this sentence. The threshold issue is whether the court has authority to decide this dispute, right? This requires analyzing personal jurisdiction, subject matter jurisdiction, and venue, right? This is going to be at the beginning of all your civil procedure essays. Remember, what is a civil case? A civil case is player on player violence, PvP, right? Why does this matter so much on the bar exam? Well, it matters because California frequently tests fact patterns where plaintiff has filed in a particular court, right? And the examiner wants you to stop and ask the question, does this court actually have the power to hear this case? It is the single easiest, trickiest, sneakiest way to make you lose points on an essay because it is the beginning point. If you get straight into the merits without addressing whether this court has authority or not, you are going to lose all your points, right? So we're going to begin. Let's see. So let's look at the three types of authority, right? And let's break each one of these down. And you're going to think of these as three questions that a court should ask itself every time a lawsuit gets filed, every time a complaint comes across, right? These are the questions the court should be asking. And it should be, let's talk about personal jurisdiction, right? Sometimes you will see this written as PJDX, right? JDX is jurisdiction. So you can write PJDX and know you're talking about personal jurisdiction. Now, personal jurisdiction is the court's authority over the parties, over the people to the lawsuit, right? It specifically asks, does this court have the power to compel the defendant to appear and defend the lawsuit in this state? Now, as we're going through jurisdiction, I want you to hear me say state, in this state, right? Because we have state suits and then we have federal suits, right? And so when we're looking at the different types of jurisdiction, it's going to be different about whether you're in state court or federal court. Now, personal jurisdiction is about the court's power over people, right? Personal people, keep your P's together, right? And the defendant in particular, personal jurisdiction over people, and it's the defendant in particular that we're focusing on. Without personal jurisdiction, the court has no authority to enter a judgment that binds the defendant. This is a constitutional requirement derived from the Due Process Clause of the 14th Amendment. Now, let's talk about subject matter jurisdiction. Subject matter jurisdiction is the court's authority over the type, right? Over the subject matter of the case. And it asks, does this court have the legal power to hear this category of dispute, right? Subject matter jurisdiction is about the court's power over this type of claim, right? Where we have personal people, specifically the defendant, subject matter is talking about the type of claims. Now, federal courts, we're talking about subject matter jurisdiction, federal courts are courts of limited jurisdiction. Article 3 courts, federal courts are courts of limited jurisdiction. Congress has defined the narrow categories of cases that they may hear. Why? Because they're courts of limited jurisdiction. So if a case does not fall into one of the categories that the feds say, these are the cases we're going to hear, then the federal court has no power to hear it. Period. End of story. Sayonara, right? And critically, unlike personal jurisdiction, subject matter jurisdiction cannot ever be waived You cannot waive subject matter jurisdiction. And subject matter jurisdiction, it can be raised at any time, even on appeal, right? So subject matter jurisdiction is a multiple choice question and it cannot be waived. And the second multiple choice question is it can be raised anytime, even on appeal. Those are two guaranteed multiple choice questions. And then venue, right? Venue asks whether the geographic location, right? The physical location, which specific federal district court is the proper place for this lawsuit to be filed, right? Venue is not about whether the court has power, right? And that's what personal and subject matter jurisdiction are about, is does this court have the power? Venue is not about whether the court has the power. It's about the geography. So even if a court has personal jurisdiction and subject matter jurisdiction, the lawsuit must be filed in the correct district, right? Unlike subject matter jurisdiction, improper venue can be waived if not timely raised. So if you do not bring improper venue in a timely manner, then it is waived. And unlike dismissal for lack of jurisdiction, a case with improper venue, that can often be transferred rather than just dismissed, right? So personal jurisdiction, subject matter jurisdiction, can the court even hear this? And venue is more of, okay, now we have PJ, we have personal and subject jurisdiction. Now, where are we going to have the case? Which fancy courthouse is it going to be in? So when you're on the California bar, always address the three in order: personal jurisdiction, subject matter jurisdiction, and venue. Even if one issue seems obvious or conceded, you still have to mention it because examiners are going to award points for you showing your framework. So now let's get into personal jurisdiction, right? Let's dig into it because this is one of the most conceptually rich areas of civil procedure, and it's heavily tested. So, under a California bar analysis, courts examine three things, you guys, in sequence when determining personal jurisdiction over a non-resident defendant. Three things, okay? 1, traditional bases of jurisdiction. 2, state long-arm statutes. And 3, the constitutional limits, which are also called the minimum contacts test. Now, a lot of students get very confused in the differences between traditional bases of jurisdiction, number 1, and number 3, the constitutional limits. So I want you to consider this, like Crystal has up on the screen, your short, easy to memorize, first memorized outline. Traditional bases, long arm, constitutional limits, right? Personal jurisdiction, subject matter, venue. Keep your threes, right? We know the first three. These are the next three: traditional basis, long arm, and constitutional limits, okay? So let me explain why we go through these 3 steps in order. Personal jurisdiction is both a statutory question and a constitutional question. So first you need a state statute that authorizes the court to assert jurisdiction. Then that exercise of jurisdiction must be constitutionally permissible under the Due Process Clause. So when we're looking at traditional bases, historically, courts could assert jurisdiction automatically if one of a handful of conditions was met, right? And that's why these are called the traditional bases of jurisdiction. And if any one of them applied, personal jurisdiction was established without any further analysis, right? You didn't need to analyze the long arm statute or the minimum context test. And our traditional bases are domicile, service of process while physically present in the state, and consent. We have our long arm statute. So if no traditional basis applies, right? Well, what did we do? We advanced. We started with the traditional basis test, right? But then we had to get a little bit more creative, right? So think about the traditional basis, the long arm statute, and the constitutional limitations as this continued development over time. We started with the traditional basis, right? Are you domiciled here? Did we physically serve you while you were here, or did you consent by coming into court? right? Then we took the next step. If no traditional basis applies, then the court looks to the state's long arm statute. Now, a long arm statute is a state law that authorizes courts to exercise jurisdiction over non-resident defendants, defendants who are not physically present in the state, when certain conditions are met. And this is how courts reach out to those out-of-state defendants. Now, we didn't just stop at the long arm statute because we took one more step and we made it a little bit more complicated, right? We said that even if traditional basis or long arm statutes apply, the exercise of jurisdiction must not violate the defendant's constitutional rights under the Due Process Clause of the 14th Amendment. Now, this is where the minimum contacts test, this is the international shoe case, you guys. This is where that test comes in. Now, this is the heart of the personal jurisdiction analysis. We're going to get into the elements under each of these as we go, but this is the basic, right? Personal jurisdiction, subject matter jurisdiction, venue, right? Under personal jurisdiction, right? You should have personal jurisdiction, traditional basis, long arm statute, constitutional limits. Now make your outline even bigger, right? Fill it out, go back in and fill in. You should have personal jurisdiction. Under it, you should say traditional basis. Then you should have domicile, physical service consent, long arm, constitutional limit, minimum contacts under due process, right? And as we go through, you're going to break it out every time we go. All right, so there are three classic traditional bases for personal jurisdiction. This is the first thing, right? This is the old school thing. This is the first one we're going to address. Now, if any one of these applies, the analysis for personal jurisdiction can end here, right? The court has the power over the defendant. You don't really need to go further. You want to pick up points, right? Because we don't want to write ourselves out of an essay, but it's going to depend on the essay. But generally, this is where you could end it. So let's talk about domicile. Now, domicile is the place that a person considers their permanent home, the state where they are physically present and intend to remain indefinitely. A person can only have one domicile at a time, even if they have multiple residences. So if the defendant, so I want you to hear the two terms here. The two terms in domicile are the two terms in where do you live is domicile and residence. The rule statement on domicile is that domicile is the place a person considers their permanent home, where they are physically present and intend to remain. A residence is just a place where you reside, all right? So if the defendant is domiciled, meaning they are physically present and they intend to remain indefinitely in that forum state, then the court has jurisdiction over them regardless of where the case of action arose or where the defendant is currently located. Domicile-based jurisdiction is considered general jurisdiction, meaning that the court can hear any claim against that defendant, not just claims arising from their forum state activities. For corporations, it's different, right? A corporation's domicile is determined by statute, right? And a corporation is treated as a dual citizen, meaning that if you're an individual, you can only have one domicile, right? But if you're a corporation, we have options. And so the corporation can be considered domiciled in the state where it is incorporated and the state where it has its principal place of business, or through the nerve center test, stating where are the administrative offices, where are a majority of the working employees, right? And their principal place of business, that's the nerve center, right? And we're going to look at that a little bit more on the next slide, but we're just going at it little by little, right? Now let's look at this tag jurisdiction, the traditional basis, right here, number 2, box 2, right? This is called in-state service jurisdiction. This is when we're talking about service of process, right? Domicile, service of process, or consent. The official name for this is tag jurisdiction. It's transient or in-state service jurisdiction. And this allows a court to establish personal jurisdiction if the defendant is personally served with process while physically present in the forum state, even if the visit is brief or temporary. Right? This is one of the oldest and most fun rules in civil procedure because it doesn't matter why the defendant is in the state or how long they're there or whether the cause of action has any connection to the state. If you are served, right, while you are physically present, even if you're just passing through on vacation, guys, then jurisdiction is established, which is why we used to have those people, those process servers who would wait in airports. And the moment the airplane would touch down, they would hand process of service. And so here's a hypo that expresses that. So imagine the defendant, a New York resident, is on a 2-day vacation in California. While he's sitting at a restaurant in San Francisco, he is served with a summons and a complaint in a contract dispute that arose entirely in New York. Well, the California court has personal jurisdiction over the defendant. He was physically present when served, and that's all the traditional basis requires. Now let's talk about consent, right? Consent occurs when a defendant voluntarily accepts the jurisdiction of a particular court, right? Consent is a waiver of the right to object to personal jurisdiction. And remember, you guys, anytime we talk about waivers can always be expressed or implied. And so you can waive your personal jurisdiction, either express or implied, right? So consent can happen in 4 different ways, right? It can happen because you appeared in the action without objecting, right? So if a defendant participates in litigation and fails to raise a timely jurisdictional objection, you've consented, right? The second way is a forum selection clause in a contract. If you agree in advance to resolve a dispute in a particular court, then a defendant who signed that clause in the contract, well, then they've agreed to consent to the jurisdiction there. The third is appointment of an agent for service of process, right? And we all know how that works. When you designate an in-state agent, that's you consenting to service and jurisdiction in that state, which is why so many state laws require that you have a service processor in that state, because then that's you consenting to jurisdiction. And then there's implied consent by statute, right? So imagine, right, non-resident motorist statutes, right? They provide that any non-resident who drives on state roads impliedly consents to jurisdiction in that state for claims arising from accidents on those roads, right? That is, and we'll get into this, but that's you taking advantage of the protections of that state. Now, on the California bar, always check all 3 traditional bases first. If a traditional basis applies, personal jurisdiction is established and you can move on, right? Many students are going to waste their time on minimum contacts when a simple traditional basis would resolve the question. All right, now let's move on. Now, because corporations are so frequently tested and they're frequent parties in litigation, the rule for determining when corporate domicile when we're trying to determine corporate domicile for jurisdiction purposes is very important because they test this over and over and over. They love to test this. Now, remember, a corporation is a citizen of every state in which it's incorporated and the state in which it has its principal place of business. For diversity purposes, a corporation can only have one principal place of business. Now, when we're trying to determine the principal place of business, we use the nerve center test, right? Now, the principal place of business is the place where a corporation's high-level officers direct, control, and coordinate the corporation's activities, right? This is the nerve center. In practice, this is almost always where the corporate headquarters is. The nerve center test asks where the strategic and managerial decisions are made. Where do the officers and directors sit? Where are the decisions that guide the company's directions made? Right? This is not necessarily where the company does most of its business or even where most of the employees work. It is where the brains of the operation are, right? It's where the brains of the operation are. So be wary for those questions that are like, most of the employees were in state X, but all the management was in state Y, All right. Because if management is running the business, then that's where the brains are. And that means that the nerve center will be in state Y. So let's take Amazon. Let's do a hypo with Amazon. So Amazon is incorporated in Delaware, and its headquarters are in Seattle, Washington, where the CEO and all the top officers direct corporate strategy. For our jurisdictional purposes, Amazon is domiciled in both Delaware, which is where it's incorporated, and Washington, which is the principal place of business under the nerve center test. So this means if you're suing Amazon, complete diversity is destroyed if any plaintiff is from either Delaware or Washington. And we're going to get into complete diversity next. But why does this matter? Well, because in diversity jurisdiction cases, a plaintiff must ensure that no plaintiff shares citizenship with any defendant. And for corporate defendants, that means checking both the state of incorporation and the state of the principal place of business. Miss either one of those, and your diversity analysis is wrong. So remember, lots of students forget that a corporation actually has two states of citizenship, the incorporation and principal place of business, and both must be diverse from all opposing parties when we're doing subject matter jurisdiction. If the problem says ABC Corporation is incorporated in Delaware and headquartered in California, then that corporation is a citizen of both states. People can only have one domicile, but corporations can have two. Now, if no traditional basis of jurisdiction applies, then we move on to step 2, right? And that's the state's long arm statute. Now, a long arm statute is the mechanism by which a state extends its judicial reach to defendants who are not really physically present within its borders. So, a long arm statute is a state law that authorizes courts to assert personal jurisdiction over non resident defendants who have certain types of connections to the forum state, such as transacting business there, committing a tort there, or owning property there. Right? Now we have this specific California rule, right? California, like many states, has adopted a maximum reach long arm statute. This is called a coextensive long arm statute, right? California's long arm statute authorizes its courts to exercise jurisdiction to the full extent permitted by the United States Constitution, right? It is a coextensive long arm statute. In California, right, step 2 collapses into step 3 because California's long arm statute extends to the constitutional maximum. It's coextensive. The only question that matters is whether the exercise of jurisdiction satisfies constitutional due process. There's no separate statutory gateway to pass through. Some states have enumerated long arm statutes, right? And those enumerated statutes, they list specific categories of conduct authorizing jurisdiction. Things like transacting business, committing a tort, contracting to perform services. And in those states, you have to analyze whether the defendant's conduct fits into one of those categories before you get into your constitutional analysis. But in California, you skip that step. You state that California has a coextensive long arm statute that allows it to go as far as the Constitution allows, and then you move on, right? And this is important, right? Because they're going to test you on this California specific coextensive long arm statute. They always test on that. So remember, after checking those traditional bases, note that the California long arm statute extends to the full constitutional limit. Therefore, the analysis turns on whether the exercise of jurisdiction satisfies the minimum contacts test under the due process clause. So remember, always include that transition when you're on the California bar. Under California's coextensive long arm statute, which extends the full constitutional limit, jurisdiction is proper if and only if it satisfies constitutional due process requirements. This shows the examiner that you know the California specific rule, and they love to test California specific. Now we reach the most important and the most tested concept in personal jurisdiction, the constitutional minimum contacts test. Now, this test determines the outer limits, the outside of what the due process clause allows when a state tries to exercise jurisdiction over a non-resident defendant. Notice we are focused on the defendant here. It's all defendant, defendant, defendant. And this is where we get into the International Shoe case. You can find lots of information on it. I suggest you read it and you read some of the stuff people have written on it. The Supreme Court held that a court may exercise jurisdiction over a non-resident when the defendant has minimum contacts with the forum state, such that exercising jurisdiction does not offend traditional notions of fair play and substantial justice. This is the foundational case in personal jurisdiction law. So let me tell you a little about the International Shoe case, because I want you guys to understand how this rule showed up and where it comes from. So International Shoe was a Delaware corporation headquartered in Missouri, and they sold shoes. And they used traveling salespeople who operated in Washington state. Well, Washington sued for unpaid employment taxes. International Shoe then argued that Washington courts had no jurisdiction because the company was not present in Washington. The Supreme Court rejected the old physical presence requirement, and they established the modern minimum contact standards, right? And so the rule is a court may constitutionally exercise personal jurisdiction over a non-resident defendant where there's two things. When the defendant has minimum contacts with the foreign state and exercising jurisdiction does not offend traditional notions of fair play and substantial justice, and all the elements must be broken down and satisfied, right? The test breaks down into 3 specific elements that you have to analyze and in a specific order. And I'm going to go through each one on the next slide, but I'm going to introduce them here, right? Those 3 things in the correct order under minimum contacts are purposeful availment, foreseeability, and fair play and substantial justice. Purposeful availment asks, did the defendant voluntarily engage with the forum state? Foreseeability asks, could the defendant have anticipated being hauled into court, being hailed into court in this state? And then the third asks, is exercising jurisdiction reasonable, right? Is it fair under all the circumstances? And these 3 elements together define whether minimum contacts exist. Think of them being a funnel. Purposeful availment and foreseeability establish the contacts. The fair play and substantial justice determine whether it's constitutionally reasonable to exercise jurisdiction based on those contacts. Now, let's talk about this purposeful availment, the first element. Now, purposeful availment requires that the defendant voluntarily engage with the forum state in a deliberate way, an intentional way, choosing to benefit from its laws, choosing to benefit from its markets, its infrastructure, or its resources, right? The contact cannot be accidental. It cannot be random or the result of unilateral action by someone else, right? Can't be kidnapped. This element has 2 critical components. First, conduct has to be voluntary, right? If you're kidnapped, well, it's criminal law anyways, right? The defendant must choose to direct their activities toward the forum state. Second, it must be purposeful. The defendant deliberately targeted or engaged with the forum, not merely ended up there by chance. I was driving to Vegas and I got lost and I'm in Utah, or because somebody kidnapped them, right? So examples of purposeful availment are selling products, right? I sell products in Texas, right? Selling products to forum state customers through a distribution network, targeting that state, signing a contract with a forum state party, and contemplating ongoing business in that state, driving on the state's roads. That is absolutely purposeful availment. Advertising to that state's residents. Hey, Texas, come get me. I'm the big law hammer, right? That is you, right? Voluntarily and purposefully interacting with that state, right? Maybe you have a website that actively solicits business from state customers. That is all purposeful availment. So imagine a Texas-based manufacturer sells defective products through a distributor who ships them to California, right? And sells them to California customers. If the manufacturer, a Texas-based manufacturer, if they specifically targeted California through advertising, product customization for California, or an established distribution network aimed at California, that is personal or purposeful availment. If that manufacturer sold to a national distributor who had no awareness that products ended up in California, then this is not purposeful availment. And that's the Asahi Metal case. It's another important case that you may read or that you want to, right? And then we've got our foreseeability. Foreseeability, right? Foreseeability requires that it is objectively foreseeable from the defendant's deliberate acts that they could be hailed into court in the forum state. Now, this is HALED, which is different than HIAILED, right? But it kind of means the same thing, right? The key is not merely that a product ended up in the state, but that the defendant deliberately targeted the state, right? That they deliberately targeted. So the foreseeability question is closely related to purposeful availment, isn't it? Courts are going to ask, given the defendant's contacts with the forum state, would a reasonable defendant in that position have anticipated that they might be brought into litigation in that state? Note that this is an objective test. It does not matter whether this defendant subjectively thought about the possibility of a lawsuit, right? It is an objective standard. So a company that regularly sells goods to California customers, that advertises in California, that has California sales offices, or maybe they contract with California businesses, they should be reasonably anticipating the possibility of being sued in California, of being hailed in a California court. That foreseeability is exactly what makes it fair to subject them to California jurisdiction. Now, let's talk about fair play and substantial justice. So even when minimum contacts exists, right? Even when we have minimum contacts, a court still has to determine that exercising jurisdiction is constitutionally reasonable, that it does not offend traditional notions of fair play and substantial justice. And that's how I hear this. Traditional notions of fair play and substantial justice. It seems like some old, muckety muck stuff, right? So don't forget to end your stuff with your muckety mucks, right? Courts are going to balance 5 specific factors, you guys, when they're addressing fair play and substantial justice. First, the burden on the defendant, right? They're going to say, how inconvenient is it for the defendant to litigate in this forum, right? International or cross-country travel may be relevant, right? It might not work. There's the forum state's interest, right? Like, does the state have a strong interest in adjudicating the dispute? And a state has a strong interest in protecting its residents and regulating conduct within its borders. So if you're driving around, you get in a car accident, the forum state has a real interest in protecting drivers, right? Third, the plaintiff's interest in convenient relief, right? Where can the plaintiff most effectively obtain relief? Because it matters. If it's going to be difficult for the parties to show up, right? The judicial system's interest in efficiency. What forum will most efficiently resolve the dispute and hear the evidence? And then the shared interstate interest, right? Which forum best serves the shared interest of the states in furthering fundamental social policies? So remember, on the bar, if you establish purposeful availment and foreseeability, fair play and substantial justice will rarely defeat jurisdiction. It rarely defeats it. It functions more as a safety valve. It's your Hail Mary pass. However, you must mention the factors and note that the burden of showing unreasonableness falls on the defendant once minimum contacts are established. So now that we've covered how courts establish personal jurisdiction, let's look at the structural types of personal jurisdiction, because there's different types, right? It's never just one size fits all. There's 3 types, right? And each is based on a different jurisdictional hook, right? They've all got their own flavor. And you have to be able to identify which flavor is in a given fact pattern, right? So in personam, if you did not take Latin, well, you might as well consider this your Latin class, right? In personam, right? In person. In personam jurisdiction is jurisdiction over a person. Straightforward, right? It's the most common form of personal jurisdiction. The court's judgment binds the defendant personally and can be enforced against all of the defendant's assets, wherever they're located. In personal jurisdiction, in personam jurisdiction is what we've been discussing throughout this lecture, basically. Jurisdiction established through domicile, through service of process, consent, or the minimum contacts test. When a court has in personam jurisdiction, it can render a money judgment against the defendant that could be domesticated and enforced in any other state under the full faith and credit clause of the Constitution. This is the gold standard of personal jurisdiction for plaintiffs because the judgment follows the defendant everywhere. You can't get out of it. If a defendant has $5 million in real estate in Michigan and you win a California judgment against them, you can enforce that California judgment against the Michigan property. Then we have in rem. In rem. That is jurisdiction over property, physically located in the forum state, right? So the court adjudicates the rights of all persons with respect to that property. It binds the world, not just the parties. In rem actions, those determine ownership rights or other legal interests in specific property. The classic example that you will get if you have to discuss in rem jurisdiction is quiet title. So at the beginning of this, where we said, oh, you're going to start noticing property and constitutional law and civil procedure merge. You're going to start civil procedure and con law merge. Well, here we go, right? Because in rem actions, right, they're classically tested under quiet title, right? A lawsuit to establish who owns a particular piece of real estate. Because the property is physically in the state has inherent authority to adjudicate rights in that property. Notice is still required, right? A court cannot determine property rights without at least attempting to notify interested parties, but in rem is over property. And then we have our quasi in rem. Now, quasi in rem jurisdiction, uses, I have words. Quasi in rem jurisdiction uses property located in the forum state as a jurisdictional hook, right? Historically, quasi in rem jurisdiction was used as a workaround. If a plaintiff could not establish in personam jurisdiction over the person, right, then they might attach the defendant's property within the state and use that property as the basis for the suit, right? However, the Supreme Court significantly curtailed this doctrine. And this is the Schaefer v. Heitner lawsuit. Schaefer v. Heitner. Okay. The Supreme Court held that the minimum contacts test must be satisfied even for quasi and rem jurisdiction. Property alone without minimum contacts between the defendant and the forum state is no longer sufficient to establish jurisdiction. This basically eliminated quasi and rem as a meaningful alternative to the minimum contact. After Schaefer, quasi and rem jurisdiction essentially requires the same analysis as in personam jurisdiction based on minimum contacts. The property may still be relevant as evidence of contact with the forum state, but it alone is no longer enough. All right. It alone is no longer enough. Now, even after a court, and I wonder why my headings aren't showing on this thing, but even after a court establishes that it has personal jurisdiction over a defendant, there's one more constitutional requirement before the case can even move forward, right? The defendant must receive notice of the lawsuit and an opportunity to be heard. This requirement should sound familiar because it's grounded in the Due Process Clause, the same constitutional provision that limits personal jurisdiction, right? And so this is our Mullane v. Central Hanover Bank case, right? The Supreme Court held that due process requires notice, reasonably calculated under all the circumstances to apprise interested parties of the pendency, meaning the pending action, and to afford them an opportunity to present their objections, right? The form of notice must be practically sufficient, not a legal fiction. It has to be practically sufficient. Now, the key concept from Malone is reasonable calculation. That's what we're keying in on here. The court does not require actual notice. Some defendants are going to evade service or simply we're not going to find them. But the plaintiff must use a method that is reasonably likely under the circumstances to actually reach the defendant. If a better method is available and practical, a lesser method will not satisfy due process. So under the Federal Rules of Civil Procedure, Rule 4, and remember, you don't need to specifically remember the rule numbers. You can. If you do, good for you. Not required, though. Service of process may be accomplished in several ways, right? And this is under the federal rules. Under the federal rules, you can do service of process through personal service, substituted service, mail service, or publication. Personal service, that is direct physical delivery of the summons and complaint to the defendant. This is the gold standard because it's virtually certain to provide actual notice, right? Courts always accept this method. The second time is substituted service, and that's where you're going to leave the summons and complaint at the defendant's usual place of abode, all right, with the person of suitable age and discretion who lives there. Also acceptable is delivery to an authorized agent, right? So if you're going to go to a big corporation, you might give that to the secretary, right? Mail service. Certain states, you guys, authorize service by certified or regular mail under specific circumstances. Under federal rules, a party may also waive personal service by agreeing in writing to accept service by mail. And then publication. This is last resort, right? And this is permitted only when the defendant's whereabouts are unknown and other methods are impracticable. Courts really scrutinize this. They look at this very carefully because it's the method least likely to provide actual notice. Like service by publication is problematic, and courts only allow it when there's no better alternative, right? And they interpret Mullane to require actual notice whenever the identity and address of an interested party is known or reasonably ascertainable. So on the bar, if a fact pattern involves a question about whether the defendant received adequate notice, go straight into Mullane's reasonably calculated standard and ask yourself, given what the plaintiff knew about the defendant's location and circumstances, was the method used reasonably likely to actually inform the defendant? If a better method was available and not used, then service is going to be found constitutionally deficient. So now we're moving to the second pillar, right? This is our second one. This is subject matter jurisdiction. So even if a court has perfect, as Donald Trump likes to say, perfect personal jurisdiction over the defendant and notice has been properly given, the court still might not be able to hear the case if it lacks subject matter jurisdiction, right? So federal courts are courts of limited subject matter jurisdiction. They may only hear cases that Congress has empowered them to hear, right? Through a grant of jurisdiction authorized by Article 3 of the Constitution. Article 3 courts are courts of limited jurisdiction and may only hear federal question jurisdiction in diversity of citizenship cases, right? Like we need to know federal question and diversity of citizenship. This stands in contrast to our state courts, right? State trial courts are courts of general subject matter jurisdiction. They can hear virtually any civil claim, subject only to specific statutory exceptions. So if a claim has no home in federal court, then state court is usually the proper forum. But if you want to be in a federal court, you have to fit into one of these two federal categories. There's one more critically important rule about subject matter jurisdiction that distinguishes it from personal jurisdiction and venue. Subject matter jurisdiction cannot be waived. It is in the federal courts. It's very important, right? Federal court super serial. A party can waive the right to challenge personal jurisdiction by appearing without any objection, right? By making a general appearance. A party may waive venue by failing to timely object. But the lack of subject matter jurisdiction can be raised at any time by any party or even by the court itself, even for the first time on appeal, even after a full trial. So that's important to know. And that's critical, right? Personal jurisdiction and venue can be waived if they're not timely raised, right? Subject matter jurisdiction cannot be waived ever. A court that realizes mid-trial that it lacks subject matter jurisdiction, it has to dismiss the case. So write this distinction in your essay. Unlike personal jurisdiction, subject matter jurisdiction may not be waived, right? And may not be waived and may be raised at any point. Now, federal question jurisdiction, right? Because we have two of them, diversity and federal question. Federal question jurisdiction exists when the plaintiff's claim arises under the Constitution, under the laws or treaties of the United States, right? This is just the most straightforward path into court. The federal court must appear on the face of the plaintiff's well-pleaded complaint, right? So let's hit well-pleaded complaint, right? Federal question jurisdiction is determined solely by what appears on the face of the plaintiff's well-pleaded complaint. The court does not enter the defendant's it doesn't consider the defendant's anticipated defense, right? The defendant's answer. It doesn't consider counterclaims or any other responsive pleadings. If the federal question appears only in defense, then there is no federal question jurisdiction. It has to be on the face of it, right? It has to say, you violated the Constitution, civil rights, right? Title VII of the Employment Discrimination, patent and copyright, right? Due process. This rule prevents the plaintiffs and defendants from making up or destroying federal jurisdiction through specific pleadings, right? So the court looks only at what the plaintiff has affirmatively alleged. What right or interest is the plaintiff asserting? And is it substantially founded on federal law? So, for example, right, federal jurisdiction exists where the plaintiff brings suit alleging the defendant acting under color of state law violated your Fourth Amendment rights. The federal question, a constitutional civil rights claim, appears on the face of the complaint. Federal question jurisdiction is proper. What about this one? This hypothetical. Plaintiff sues for breach of a state law contract. Defendant plans to raise federal preemption as a defense. Even though federal law is involved, it appears only in the defense, not in the plaintiff's complaint. Therefore, no federal question jurisdiction sits. So it has to be on the face of it, right? Very important. Notice that there is no amount in controversy requirement for federal question jurisdiction. A civil rights claim worth $500 can be in federal court. A patent claim worth $100, that can be in federal court. The federal question alone, appearing on the face of the complaint, is sufficient. Now, let's do diversity jurisdiction because this is more heavily tested. Diversity of citizenship jurisdiction exists where there's two things. The first thing is the lawsuit is different between the citizens of different states. That's complete diversity. And two, the amount in controversy exceeds $75,000, right? Exclusive of interest and costs. And both of those requirements must be satisfied simultaneously. They do. They love to test this. So let's talk about how we get to complete diversity, right? Every plaintiff, right? And if you have to draw a picture, put your PVD down on your paper, right? Every plaintiff must be a citizen of a different state from every defendant, right? A single overlap in citizenship between any plaintiff and any defendant destroys complete diversity, and it eliminates federal jurisdiction. This is the most common source of error in diversity analysis on the bar. Complete diversity means every plaintiff versus every defendant, not just one plaintiff versus defendant, right? So on the board, we've got some examples, and they look like some kind of weird bookie spreadsheet, right? It's like PCA VD1 NV plus D2 AZ. This is what it starts looking like when I'm like, you have to start writing these things down. You have to start drawing pictures so that you can remember. right? So we have our plaintiff. Our plaintiff is in California versus our first defendant in Nevada and our second defendant in Arizona. Well, we've got no overlap here between our defendants and our plaintiff, right? Federal jurisdiction is proper. Now let's look at the example underneath that. We have one plaintiff in California. We have two defendants. One of the defendants in Nevada, the other defendant is in California. Rot-row-roarge. The plaintiff and the second defendant share a California citizenship. That destroys diversity, right? So there is no diversity. We're done. That sucks, huh? Now, an individual citizenship for diversity purposes is in their domicile, right? Not their residence. And domicile, right? We learned what that is. Where do you intend to be, right? Where are you and where do you tend to remain? That's that physical presence in the state combined with the intent to be there indefinitely. And a person can only have one domicile, even though they may have multiple residences. And remember, as we discussed earlier, a corporation is a citizen of every state where it's incorporated and the principal place of business. Remember, both must be diverse from all opposing parties. So you want to start drawing out these pictures because when you're working with a corporation or with a business that might have two domiciles, if you're not noting both of those, you may end up missing that there is no diversity of citizenship, right? Now, the second requirement is that amount in controversy exceeding $75,000, right? The amount in controversy, it must exceed $75,000, meaning it must be at least $75,000.01. A claim of exactly $75,000 is not sufficient. It has to be $75,000.01. Right? The plaintiff's good faith allegation of the amount controls, and the case will be dismissed for lack of jurisdiction only if it is legally certain that the claim cannot reach the threshold. Right? The good faith standard is permissive. Courts will not dismiss simply because the plaintiff ultimately recovers less than $75,000, you guys. Jurisdiction is determined at the time the case is filed, based on that plaintiff's good faith belief about the value of their claim being over $75,000.01, right? Interest, though, interest and costs, that does not count towards the threshold. But punitive damages and attorney's fees, when it's authorized by statute, and injunctive relief can. So, the statute says exceeds. This means the claim must be more than $75,000. So if you get a multiple choice question of a claim that's exactly $75,000, right? Then that's not going to satisfy diversity jurisdiction unless it's $75,000.01. And remember, diversity citizenship is tested at the time the lawsuit is filed, not later. It is at the time it is filed. Subsequent changes in domicile, once you file, if you change your domicile, that will not affect jurisdiction that has already been established. That is a common way they try to throw that test off on you guys. Now, we've got two additional doctrines which are important here. We've got removal and supplemental jurisdiction. Now, removal allows a defendant to transfer a case from state court to federal court when the federal court would have original subject matter jurisdiction over the case, meaning that federal question jurisdiction or diversity jurisdiction exists. Now, removal recognizes that a defendant should not be disadvantaged because the plaintiff chose state court when federal court was available, right? The defendant can exercise their right to a federal forum by removing the case. Now, the rules for removal are strict, and there's 5 of them, right? There's really 4, but there's a 5th one. There's a special rule for diversity cases. First, only the defendant can remove the case, right? And that's because the plaintiff chose the forum, right? And they can't remove their own case. If the plaintiff wanted federal court, then they should have filed there. So this gives the defendant an option. Second, the case must be removed to federal district court, embracing the state court where the case was filed. You cannot move this to an unrelated district, all right? So pay attention to that. Third, all the defendants must consent to the removal. So if there are multiple defendants, every single one of them must agree. If there's one dissenting defendant, then that's going to block the removal. 4, the notice of removal must be filed within 30 days of the defendant receiving the complaint or within 30 days of the case becoming removable. And then 5th, this is a special rule for diversity cases, right? A defendant who is a citizen of the state where the action is filed cannot remove a case based on diversity jurisdiction, right? The protection of diversity jurisdiction is for out-of-state parties. As an in-state defendant, you don't need those protections, so we're not going to give them to you. Now, we also have what's called supplemental jurisdiction here. And supplemental jurisdiction allows that federal court, right? Because we're talking about diversity and diversity jurisdiction and federal question jurisdiction, right? So supplemental jurisdiction allows a federal court in a case where it has proper subject matter jurisdiction over some claims to also hear additional state claims that would not independently qualify for federal jurisdiction, provided that those claims share a common nucleus of operative fact, a common nucleus of operative fact with the main federal claim. Now, the rationale for supplemental jurisdiction is judicial efficiency. If the same core facts give rise to both a federal claim and a state law claim, it makes sense to hear them together in one lawsuit rather than wasting the court's time and requiring the plaintiff to pursue parallel state and federal litigation, right? And so federal courts have supplemental jurisdiction over claims that are part of the same case or controversy as the claim conferring original jurisdiction. And the test is, do the claims share a common nucleus of operative fact such that they would be ordinarily tied together? So even when supplemental jurisdiction technically exists, the court has discretion to decline it. Courts can decline supplemental jurisdiction when the state law claims predominate over federal claims, where the federal claims are dismissed early in litigation, or the state law issues are novel or particularly complex, and a state should address them first. So on the California bar, when you see a federal case with additional state law claims, ask 2 questions. Do they share a common nucleus of operative fact with the federal claim? And is there any reason the court should decline to exercise supplemental jurisdiction? So now that we've covered personal jurisdiction and subject matter jurisdiction, now we're getting into venue. And venue is the geographic location, right? Venue in federal court refers to the specific federal district where a lawsuit has to be filed. Even a court with proper personal and subject matter jurisdiction can't proceed if venue is wrong, right? Though it's not like subject matter, improper venue can be waived and it can be cured by a transfer. So venue in federal civil action is proper, right? In 1, a judicial district where any defendant resides, if all the defendants reside in the same state. 2, a judicial district where a substantial part of the events or omissions giving rise to the claim occurred, or where a substantial part of the property at issue is situated. Or 3, the fallback. If neither 1 or 2 applies, any district where the defendant is subject to personal jurisdiction, right? So that means that we've got some options, right? Venue option 1 is the defendant's residence. Now, this option is available only if all the defendants reside in the same state. If they do, the plaintiff can file in any federal district within the state where any defendant resides. If the defendants are spread across multiple states, this option is not available, and you have to move on to a different option, right? So what's another option 2? Substantial events, right? This is the most commonly applicable venue provision. The plaintiff may file in any district where a substantial part of the events giving rise to the claim occurred. Note that the statute says substantial, not all, not most, not the place where the harm was the greatest, right? And so multiple districts can qualify simultaneously. So imagine you sign that contract in New York, Or imagine that we negotiate the contract in New York, but we sign it in California, and then I breach it in Texas, because that happens, right? Each of these districts could qualify as a place where a substantial part of the events giving rise to the breach of contract occurred. So the plaintiff can choose amongst them, right? Subject to considerations of personal jurisdiction over the defendant in each. Now, our third option, this is our venue, our fallback. So if neither option 1 nor 2, if neither substantial events nor the defendant's residence works, and this is very rare, then the plaintiff may use the fallback provision. So in a diversity case, venue is proper in any district where any defendant is subject to personal jurisdiction. In other federal cases, venue is proper in any district where the defendant may be found. Now, when venue is improper, or when their venue is technically proper, but the case would be more appropriately heard elsewhere, courts have two tools. They have transfer, and then they have forum nonconvenience, and both are tested, right? Transfer allows a federal court to move a case to another federal district court where their case could have been brought originally in the interest of justice and for the convenience of the parties and the witnesses. And transfer is available in two scenarios. The first is where venue is actually improper, right? And the second is when venue is proper but inconvenient, right? So the receiving court, called the transferee court, must be a district where the case could have been filed originally, meaning the transferee court must have both personal jurisdiction over the defendant and proper venue. Now, the case that you want to read is the Van Dusen v. Barak case. So when a case is transferred, right, the transferee court must apply the substantive law of the state of the transferor court. This prevents forum shopping, right? We don't want forum shopping to occur through transfer. So a plaintiff cannot benefit from transfer to a more favorable substantive law forum. And courts balance several factors in deciding whether to transfer: the convenience of the parties, the convenience of the witnesses, which is usually the most important factor, access to evidence and documents, relative ease of access to source of proof, and the interest of justice. Now, the party seeking transfer, he bears the burden of showing that these factors weigh in favor of the new forum. Now we've got forum nonconvenience and dismissal for an inconvenient forum. Now, forum nonconvenience is a doctrine that allows a court to dismiss a case when another forum, right, typically a foreign court, is substantially more appropriate and convenient, even though the current court has proper jurisdiction and venue. Forum nonconvenience is used primarily when the more convenient forum is a foreign country, right, where transfer is really not possible. Courts will dismiss in favor of a foreign forum when the private and public interest factors strongly favor litigating abroad, right? So if some of you remember the Ilian case where we had the custody over a Mexican child, God, it was so long ago, and I think the parent, like one of the parents was in Florida, another one of the parents was in Mexico. I think that should have been forums nonconvenient, because even though the mother was in Florida at the time, I don't believe she was ever a citizen. If she was, maybe that's why they kept it. I don't know. But that's really the only thing I can think of to get to a forum nonconvenience when you're dealing with some type of foreign court system. Now, before we close, and I'm doing good on time here, I'm only 6 minutes over, how embarrassing. I'm going to walk you through exactly how to structure a civil procedure authority question on the California bar exam. Now, the structure is everything, right? And examiners are looking for your organized, top-down, sequential analysis, right? So, our opening sentence: the threshold issue is whether the court has the authority to decide the dispute. This requires analyzing personal jurisdiction, subject matter jurisdiction, and venue, right? So, for each of the three components, use this internal structure. State the rule. What is the legal standard or the test? Apply the rule to the facts. Go through each element. Reach a conclusion. Does the court have this type of jurisdiction? And then note any waivers, cures, or special considerations. Now, the full three-step sequence is personal jurisdiction. Start with traditional bases: domicile, tag jurisdiction, also known as service of process and consent. If none of those apply, then go to the long arm statute. Note that California has a coextensive long arm statute, which extends to the constitutional limits. Then analyze your minimum contacts. That's purposeful availment, voluntary targeting of the forum state, foreseeability, right? Could the defendant anticipate being hailed into court here? And then the fair play and substantial justice, right? Balance the 5 factors. Then identify the type of jurisdiction. Is this in personam? Usually it is. Is this in rem? I've rarely seen that. Or is it quasi in rem? Less likely. I don't know if I've seen that. Then once you've done personal jurisdiction, move into subject matter jurisdiction and ask whether there is federal question jurisdiction. Does the federal issue appear on the face of a well-pleaded complaint? Or are we arguing diversity jurisdiction, which means there's complete diversity. Every plaintiff is different than every defendant, and the amount in controversy exceeds $75,000. If relevant, then address removal, right? All defendants must consent. There's a 30-day deadline, and there's no in-state defendant in diversity cases. And then address supplemental jurisdiction, right? If there is a common nucleus of operative fact. Once you've done the jurisdictions, then you get into venue, right? And you want to go through the 3 options in order. The defendant's resident, if all the defendants are in the same state, the substantial events, and then that fallback. So if venue is improper or inconvenient, then you're going to get into that forum nonconvenience, right? But it's less likely they're going to take you there because that ends your analysis. Now, you may not know which issue is the quote unquote real one the examiner is testing, and that's fine. The California Bar rewards organized, comprehensive analysis. So even if personal jurisdiction is obviously proper, mention it briefly, bring it up, confirm it, move on, right? The points are in the analysis, not in the conclusion. So here's where we consolidate everything into a single reference framework, right? This is the complete picture of court authority, right? And hopefully after today, every time you see a civil procedure question, you'll be running through this matrix mentally before you write a single word, right? Personal jurisdiction, subject matter jurisdiction, venue, right? So use this screen, right? Commit this screen to like memory, right? Practice with this. And so now, you guys, here are the 5 rules that appear most frequently on California civil procedure questions, right? The international shoe standard, right? Remember, minimum contacts, right? Plus, does not offend traditional notions of fair play and substantial justice. International shoe. You apply this when there's no traditional basis, and you analyze whether a non-resident defendant may be subject to jurisdiction in a forum state. Then they love to heavily test on that complete diversity. Remember, every plaintiff, right, must be a citizen of a different state from every defendant. Don't forget your nerve center test. A corporation's principal place of business. It's PPB. That's what we call it. A corporation's PPB. Its second state of citizenship for diversity purposes is the place where its high-level officers direct, control, coordinate, right? This is usually, but not always, where corporate headquarters is. This is the nerve center test. They love to test on the well-pleaded complaint. Remember, federal question jurisdiction is determined solely by what appears on the face of the plaintiff's well-pleaded complaint. Courts will not look at defenses. They're not going to look at counterclaims. They're not going to look at responses. The federal question must be part of the plaintiff's affirmatively pled claim. And then remember your removal rules, right? Only a defendant may remove. This is a commonly tested multiple choice question. Only a defendant may remove. All defendants must consent. Removal must be within 30 days of receiving the complaint. And the case removed to the federal district, embracing the state court, right? A case removed to federal district, embracing the state court. A defendant who is the citizen of a forum state cannot remove a diversity action. So those are some of the well-tested multiple choice and rule statements. So these are the big takeaways, right? Always analyze all three all the time. Personal, subject, and then venue, right? Do it in that order. Do it every time. Follow the 3-step personal jurisdiction test, traditional basis, long arm statute, constitutional minimums, right? Then remember, federal courts are courts of limited jurisdiction. So we only allow federal question or complete diversity to get into those courts. But remember, every plaintiff has to be different from every defendant. And we got to have 75,001 cents. And then venue. Remember, venue is curable. Venue is curable. Improper venue is a waivable defect that can be cured by transfer or, in the very, very, very rare case, forum nonconveniens, right? So a court that lacks subject matter jurisdiction has no power at all. The case must be dismissed no matter how far along the proceedings are. This is very distinct than from venue and then from jurisdiction, right? And these are going to come up repeatedly. So take your time, go through master the formula. Court authority equals personal jurisdiction plus subject matter jurisdiction plus venue, right? Remember, you have to have all three. Personal jurisdiction and venue can be waived, but subject matter jurisdiction cannot. So that's a lot of information, but I know that if you sit down and you put some work into it and you start mapping out your parties, you're going to get this in no time.